This is Plyler versus Doe. It came to the Supreme Court in 1982. In 1975, the Texas legislature passed a law which did not allow for state funding to be allotted to undocumented children in the school system. This mostly affected children of illegal aliens. In addition, school districts were permitted to deny the acceptance of these undocumented children. 4 families with undocumented children sued the Tyler School District in Texas, which led to this court case. The basis of the court case came down to the 14th Amendment, once it was at the Supreme Court, dealing with equal protection. And the question was, are undocumented children under the jurisdiction of the state and thus qualify for the equal protection under the law? The court determined that undocumented children did qualify for equal protections, and thus Texas could not deny them a free public education. There were several points to the court's rationale for the ruling as given by Justice Brennan, who wrote the majority opinion. The first could be summed up around the question of who is considered a person under the 14th Amendment. They determined the intention of the 14th Amendment was to place all individuals on the same level of entitlement, pointing out that the courts do not limit this entitlement to social class. Thus, a person can be interpreted to include undocumented children. Secondly, illegal aliens are expected to keep the laws of the nation and have rights under the 5th and 6th Amendments. While it was unclear that the equal protections of the 14th Amendment applied to aliens, children of these individuals are a special case because they have little control over their parents' decisions. Third, if undocumented children are denied an education, they have little opportunity to progress, which, as Justice Brennan wrote, imposes a lifetime of hardship on a discrete class of children not accountable for their disabling status. Finally, while arguments had been made that undocumented children were a burden to the state, such as in the way of taxes or overburdening the system, the court found no evidence that denying these children was in the interest of the state.